Hey guys, it's Kathy. I hope you're doing well. So, today's stream is all about compromise. I'm going to show you one case that I know you have not seen anywhere else. I'm going to show you a second case that maybe you saw somewhere else, but I highly doubt it. I really, really doubt it. And then I'm going to show you one case that you most likely saw somewhere else because it's great. And I just can't imagine that nobody else has posted it because it's great. It's a sob sit that happened 6 days ago. So you probably already know what I'm talking about. But, it's fine. If you only watch the first two and then you dip because you already saw the third one, that's perfectly fine. It's your life. I think we're going to go to Indiana and then we're going to go to Washington. Now remember, in Washington, things go slower than in any other courts anywhere. Just do. I don't know why. But I do want to, just for people who are new, because believe it or not, some people are new to this whole court thing and they don't understand the words, just like we didn't. I want to just talk about SovSit real quick. So if you already know about it, then go make a sandwich or something. So some people go in front of the judges and they believe in this really weird set of laws that they believe is true. That, the judge doesn't have jurisdiction over them. They're not driving a car, they're traveling, and you're allowed to travel, so they don't need a license to do that. Common law rules, not the Constitution. None of the judges are legally judges because their oath is to the Constitution and not the land or God-given rights or what. It's just crazy. You're gonna hear it. It's crazy. It just gets more and more crazy as it goes. But the greatest part about this subset that we're about to see is this batshit crazy woman has a following that she brings to court with her. And that's not the only thing that's crazy. So normally subset people just sort of hurt themselves. They drive without a license. They drive without a license plate. They get pulled over. They come into court and they say, you don't have jurisdiction over me because God gave me these rights and common law and I was traveling, I wasn't driving. No. This woman found a sweet, innocent little boy and just, destroyed him in the courthouse. Never met him before and shoved her ideas down his throat. And then we'll see what happens after we didn't get to see that part. We get to see what happens because she did that. So let's get started with the first case. You haven't seen this anywhere. Promise. I promise.
State versus John Kiesler, 20D06-2301 F6101. Sir, what is your name?
John Allen Kiesler.
What's your date of birth?
4/29 of 1970.
What is your mailing address with city, state, and zip code?
1120 East Broadway, South Bend, Indiana.
Zip code?
I don't know. I'm sorry.
46601 looks like.
Yes,
Did you hear and understand the rights that I explained?
Yes, I have, Your Honor.
Okay. All right. On January 10th, 2024, probation filed a violation. This is your intimidation case where you're facing up to a year because that's what was suspended when you were convicted. And it alleges as follows. Number one, as a term of your probation, you will participate in, cooperate with, and successfully complete all evaluations, treatment, counseling, education, or other programs ordered by the court.
And I had.
Well, I don't know. No, you gotta let me read it. It says, it alleges that you completed an assessment through Oaklawn on December 6, 2023. On January 9, 2024, it says probation confirmed with Oaklawn that you canceled your orientation scheduled on January 8th, 2024, and you have no future appointment scheduled.
That is not true.
Well, they're just allegations, though.
Right, but it's not true. I was going.
It's fine. I'm going to enter a denial. I'm not saying it's true. I'm going to enter a denial.
Right.
And then it says you have not completed a moral recognition therapy. And then as a term of your probation, it says that you shall not use or possess any illegal substance. It says that you submitted to a drug screen on December 20th, 2023, and you tested positive for THC or marijuana. It says that at your probation appointment on January 4th, 2023, you admitted to the use of marijuana.
Not true.
It says you reported you used it the same day.
And I have documents from my doctor where I had to take drug screens for my narcotics pain management because I got to go for surgery here in 2 weeks. And I was testing with them. So my wife has submitted the proof of everything from my doctor. And we also have submitted a petition for an OR bond because of medical. I have to have 3 surgeries here in 2 weeks.
I was
under doctor's care
for all hold this. That thought for a moment. Your wife or whoever it is, she can file 1 million pages, and under the law, it's going to be ignored. Your wife is not a lawyer.
It wasn't ignored.
She's not allowed.
The judge actually
stop interrupting me.
Okay.
When I talk, you don't. Knock it off.
Okay. Well, we can leave then.
No, you won't leave unless I no.
Done nothing wrong.
Stop it.
I've done nothing wrong. Your Honor.
Stop interrupting me. I'm trying to answer your question and explain something. Stop interrupting me.
But you don't have to act that way to me. I'm not doing.
Stop interrupting me. When I talk, you don't. No. Stop interrupting me. Be quiet. Be quiet. Stop. Your wife cannot file paperwork on your behalf. She's not a lawyer. She's not a party to the case. Anything that she files has to be ignored. She cannot file petitions on your behalf. She cannot file a request requesting a request for you to be released on your own recognizance. She's not a lawyer. She's getting dangerously close to practicing law without a license. I don't expect her to know that. She's not in any trouble.
Right.
I would say the same thing to anyone who's got friends or family members filing things on their behalf, but it is going to be ignored. I just want you and your wife to know that. That's just the law.
Yeah.
Okay, so can you afford to hire a lawyer?
No.
Okay, then I'm going to appoint you the public defender. I'm going to enter a denial, and your next court date is February 29th, 2024 at 8:30 in the morning. I am also going to order this case transferred to Elkhart Circuit Court. Now we're done. Thank you. Have a good day.
Is there any way I can get some kind of furlough for my surgeries?
You can talk to your attorney about it. Good luck to you.
This is a garbage court, man.
Okay,
for real.
All right. You're entitled to your opinion. Goodbye.
It's garbage because I've done nothing wrong. It's all this is a garbage. I've done nothing. The allegations
Goodbye.
guys are unfair. You're not compassionate. Come on.
This is for him too.
He's not done.
And I'm assuming that Mr. Cristofino was never involved previously. No.
I don't think so.
All right. State versus Mitchell. No, sorry. Let's do, I hope I say this right. If I say it wrong, I apologize. Ordlanier Castro Nieves. Okay, 20D02-2107 F5157. Sir, what is your name?
Ordlanier Castro Nieves.
What is your date of birth?
210-689.
Can you bring him back in here, please? Bring him in here, please. Mr. Kiesler, I'm trying to do court and you're being loud. Please lower your voice. I can't hear and I can't do anything because you're being so loud out there. Please be quiet, okay? Goodbye. Sir, state your name. What is your... Get it. Come on back in here, Mr. Kiesler. Bring Mr. Kiesler back in here. Mr. Kiesler, I am not going to fool around with you, and if you don't knock it off, I'm going to hold you in direct contempt, and I'm going to impose additional jail time. I don't want this...
I don't care.
Sit down. Sit down, Mr. Kiesler.
Wrong. That's
Sit down.
You don't let anybody talk. You put allegations that are untrue.
Sit down.
I have proof. I have medical problems.
Mr. Kiesler.
And you're getting mad at me.
Stop interrupting me. Stop interrupting
me. Talk to me like that. I have value. I am a human being. You don't need to talk to me like this.
Mr. Kiesler.
Telling me to shut up.
I never used the words shut up.
Yes, you did. You absolutely did.
I never said shut up today.
Look, we're not complaining.
I told you not to interrupt me. Mr.
Look, you
Kiesler,
respect me, I respect you.
Mr.
Look,
Kiesler,
I've done
please
nothing
be
wrong.
quiet.
I've done nothing wrong.
Listen to him. I'm trying to talk to you, and every time I talk, you interrupt me. I have been nothing but respectful to everyone today.
You ain't been respectful to me. Can we go?
No, Mr. Kiesler. In fact, this is the exact opposite of what I want to happen. I have asked you multiple times to be quiet and not interrupt me. No matter how many times I say that, you continue to interrupt me. You just interrupted me again. Okay, there you did it again. I have informed you and instructed you and ordered you roughly 10 times now throughout this hearing to please not interrupt me. You continue to interrupt me, and then you're being loud out there. This is your very last warning. I'm going to allow you to leave the courtroom. I want you to be quiet. I don't want you to interrupt me. I don't want you to say anything. I want you to leave quietly and peacefully. If you interrupt me or you say anything rude or derogatory or loud, I'm going to hold you in direct contempt, and I do not want to do that.
What does that mean?
Being in contempt of court, contumacious behavior for being rude and disrespectful.
What does that mean?
And continuing to interrupt me. You don't want that. I don't want that. I want you to peacefully leave, and I want you to be quiet. Goodbye. Please leave.
I don't understand people trying to get shit resolved and they just push more shit in their bone.
Okay, state versus, let's just kind of start over. State versus Oleñar Castro Nieves, 20D02.
Unfortunately, he left quietly after that. That's just not fair. That judge should have held him in contempt. But he didn't. And there goes my dog. My dog didn't like that guy either. All right. I love that judge. I know the sound isn't matched up with the video exactly. That's because of its WebEx. And the more you record on, the further along in the hearing it goes, it gets worse and worse. But anyway, let's go to Washington. And hats off to the prosecutor. Hats off to this prosecutor. He's like, not all heroes wear capes. And I don't even like this prosecutor. He's one of my least favorites because he gets in fights with the judges all the time. And he's in the wrong in almost all of them. I think this prosecutor feels that the judges have way more power than they do. And this prosecutor wants judges to do things that judges just can't do. So, he banters with them back and forth and he loses. But today he's the star.
Hi, Ms. Capone.
Hi, Your Honor. I hear there's a Mr. Haston in the courtroom. Would it be possible for me to provide my number for him to call me?
Sure. Do you have a phone with you, Mr. Haston? Okay, so let's get you together with Ms. Capone. Can we just write down a number for him? Or? Well, your attorney's sick, I understand, and so everyone's kind of trying to backfill for him. All right, so phone number. Ms. Capone, do you have a phone number then? We'll hand you a sticky, Mr. Haston.
Yep. Let me know. 490-0801.
Okay. Mr. Haston, why don't you come on up here? We'll give you that number, give you a chance to talk to. We've got another sticky if you want it.
No, she can just repeat it one more time.
Okay, just one more time, Ms. Capone.
360-0801.
Okay, and you may have to go all the way outside to get reception. So he's going to give you a call.
Thank you, Your Honor.
Thanks. Are we ready?
Okay, so the phone call's over, and I listened a couple times to what happened in the courtroom during this phone call or before or after, and I couldn't hear anything that happened. I know he stepped out into the hall, which is right outside the courtroom, so the prosecutor heard something, and I don't know what it is, and that's what happens now.
Your Honor, our call was cut short, so I don't know if Mr. Haston
Okay.
wants more time to review his rights, or how he wants to proceed, but I'm here to advise him if he wants me to.
Mr. Haston, you need some more time on the phone? Nope. Why don't you come on up to the table then and we can get going here.
Her face says it all.
We got a couple of things to take up. Okay, so Mr. Haston, you're here January 17th, some conditions were set, and now the state has officially filed an allegation of assault in the 4th degree domestic violence, and that's what we're here about today. Ms. Capone?
Your Honor, I did not have the opportunity to review his rights with him, Mr. Haston's rights with him. I can't really take a position on his plea at this time.
Okay, so back on that first date, Mr. Haston, January 17th, you reviewed some legal rights, but you also have legal rights here now that you're charged with a crime. Everybody charged with a crime has rights. You have the right to have an attorney. We've appointed an attorney through Thurston County Public Defense. You have the right to have a trial in the matter, your choice, whether it would be a bench trial to a judge or your choice, whether it's a trial to a jury, people from the community that you would be part of choosing who would. You have the right to cross-examine, to hear from the witnesses that are being brought against you by the prosecutor. You also have the right to have the court force or compel witnesses that would say things on your behalf, to compel them to come to court. You also have the right not to say anything against yourself at trial. You cannot be forced to testify. You cannot be forced to give evidence. That's your choice. And so that's kind of that right to remain silent. And let's say that you decide to take this to trial, and whether it's to a judge or a jury, and that trier of fact finds you guilty, you have the right then to appeal it, which means ask a higher court, the superior court, to look at it all and make sure it was done right or not. And that's an appeal. So all those rights you hold. And we're got to make sure that you have a good sense of those and you have an attorney to further talk about those. But at arraignment, pleading not guilty protects all those. You keep all those rights.
That's what I would like to do, Your Honor.
Okay. So we're going to enter a plea and not guilty and make sure that you keep all those rights. And then really what we're doing here today is setting another court date. There's a couple of issues here. The court ordered that you not possess any firearms going forward and that you surrender any that you may have in your possession. And you had to respond to that order. And we haven't had a response to that. Ms. Capone, anything on that?
Your Honor, I have an order prepared, but I didn't have the opportunity to review it with Mr. Haston.
Okay, so that's kind of an important thing because it had to be responded to. Or
I do not have any weapons, firearms, or anything like that, Your Honor.
Okay.
None to surrender.
So you would be filing a declaration of nothing to surrender.
Yes, Your Honor.
Okay, and is that what you discussed, Ms. Capone?
We did not discuss it, but if Mr. Haston is okay, I will note his signature on the line.
Okay, we're okay with that. Then we'll accept that. And then there was a no contact order issued concerning Carla Haston. We've gotten, where was that? Yes, back. We set this to consider that request. And that was filed by Ms. Haston. Mr. Eastwood, are you prepared to take that up?
Yes, Your Honor.
Ms. Capone, I'm wondering, are you prepared to take that up?
Yes, Your Honor.
Oh, all right. So I've reviewed all that. And is this Ms. Haston in the courtroom? All right. And you don't have to say anything more, but if you need to say something more, I'm going to need you to be closer to that microphone with the prosecutor's table so you can be picked up on that. But if you've written it all down, I can just review that. It's up to you.
Basically, everything's on.
Okay.
Yeah.
Then we'll just go on that. Just re-reviewing it from yesterday.
I'll summarize for you. I haven't read what she wrote down, obviously, but I'll summarize for you since the judge isn't going to read it out loud. Dear Judge, please cancel this no contact with my loving husband. This was all just a very bad misunderstanding. Nothing really happened. The police and everybody have it confused. It was just a misunderstanding, Judge. There, now you know.
All right. Mr. Eastwood, the state's point of view on this request.
Thank you, Your Honor. I did have a chance to speak with Ms. Haston this morning. I do believe that her request is sincere. And up until court began addressing Mr. Haston, I think I was prepared to agree to that no contact order being removed, rescinded. However, I feel that Mr. Haston's behavior in court today is aggressive tone of speech. The short conversation he had with Ms. Capone, I'm reading between the lines there. I think there's anger issues that run through this that concern the state greatly. We would be opposing the rescission of the no contact order until there are some type of domestic violence classes or beginning of some type of anger management classes in order to address those issues. I understand that Ms. Haston was really hoping to have that rescinded today. I just think that these issues have come up during this hearing, and I just don't feel that it would be providing Ms. Haston with the maximum protection that the law can provide in a domestic violence case. I understand she wants it removed. I just don't think it is appropriate in this situation at this time.
So let me hear from Ms. Capone on your behalf, Mr. Haston, and if it's appropriate to hear from you, she'll tell me. So Ms. Capone?
Thank you, Your Honor. I would just note that any frustration Mr. Haston might have expressed today, he stands by his presumption of innocence, and I think anyone who stands by the presumption of innocence might be frustrated by this process going forward. It is a long and enduring process, but he is nonetheless showing up for court. 2 weeks have passed, and he's shown compliance with the no contact order. He's shown that he's willing to abide by the court's orders. And I would note that he has no convictions in his history that I can see. He is entitled to the least restrictive conditions of release. And given the fact that he has no prior history and he's shown that he's abiding by court's orders, I would say that it's not the least restrictive condition of release to have the no contact order in place when neither party wants it.
Okay. Is it appropriate to hear from your client or not?
I would advise against it.
Okay.
I wouldn't, Your Honor.
So you're hearing your attorney saying
She's not my attorney, though.
Well,
She's not my
Thurston
attorney.
County Public Defense. You're right.
And
She's
that's
stepping in.
what my
Let me just
frustration
tell
was,
you,
Your Honor.
just slow down. She's trying to protect your rights. She
Okay.
doesn't want you to say something on a recorded line with the prosecutor sitting
I
right there
understand
about
that,
this
but
case that
what he
might
said was
put
not
your
true.
defense
He
in
doesn't
trouble.
even know me to be able to
Well, let me
judge
ask
what,
you.
what I was feeling right then.
Let me
He
ask
doesn't
you.
even know me.
I
to
could
be
see
able to judge me.
frustration, and I
No,
understand.
because I feel like I should
Let
have
me just
time to
ask you,
talk to
slow
an
down,
attorney,
slow
Your Honor.
down, slow down.
Okay.
I just want to try and protect your rights too and make sure you don't say something about the case that's going to put you in a bad spot. So I did see you're frustrated, but I understand frustration. I'd be frustrated. You know, your attorney that you deal with is not here. He's sick. He can't be here. They're trying to fill in for you. There's this delay. It's already 10 o'clock. You were supposed to start at 9.
That's one part of it.
And then on top of it, you're being charged with a crime.
I would like
Yeah.
to go to my house. That is my house that I paid for. She doesn't pay a dime there. She doesn't have no money coming in. It's my house. I paid for it. I feel like, okay, let's go back 2 months ago when who got arrested for domestic violence and who came down here and begged
Mr.
the
Haston,
DA
I don't.
to dismiss the charges. Me.
Mr.
Okay,
Haston,
so-
I think we've made a good record for the judge.
Just, not wanting to
Well, you know, it just
get
come
you into
on.
some position that you're saying something that's going to be difficult for your attorneys to unwind. So, all right, so we've made some provisions here in this order. I'm just looking back at Judge Meyer's order, the Hickory Lane, that you can go back there and get some personal belongings, that there's provisions for electronic third-party and electronic contact allowed for finances. And in reading the probable cause declaration, I have to agree with Judge Meyer. I'm going to keep this order in effect for now. Without a change, I understand that Ms. Haston has an opinion that she wrote down. I know, Mr. Haston,
What?
don't look at her.
I'm not.
Don't turn and look at me. The order is don't have contact directly or indirectly with Ms. Haston. So
fine.
Just don't want to run you into trouble
Can I
because
ask you a
turning
question?
around.
So when I'm running from her, like when I got released from county jail, and I know
Mr.
this already.
Haston, I would advise you to.
Well, you know what? No, let's just.
So stop, Ms. Haston. I know that neither of you agree with this, but the probable cause is of, and if the facts are to be believed that were presented to Judge Meyer in the probable cause of vase hitting in the head in a time of anger and conflict, if that's to be believed, and then that's the probable cause, and that's what the court's working off of. So this order doesn't change today. We're going to set a court date, and in the meantime, you have time to talk to your attorneys at Thurston County Public Defense. Things can be discussed in between that time or at that next court date about this. So, but be sure you're in close contact with your attorneys. They can help you with this. And I know, Ms. Haston, that you're wanting this, and I understand why. However, there are lots of reasons the court issues orders. Part of this is make sure there isn't any further violence, make sure there isn't any criminal witness tampering. And I'm not saying, please don't talk over me. I know you're all emotional, but no.
I just want to go home.
All right, let me give you a
home on Anderson Island, where I live now, where I'm going to stay.
Okay, let me give you a court date. Let me just hand it to you. Well, let's print it out for you. I still have a Spanaway P.O. box. Is that good for mailing?
No.
I'm asking Mr. Haston. So we'll just hand you a court date and we'll get you on your way. And then you know how to be in touch with Mr. Kale? Or do you need that? Do you need a contact information for your attorney?
Sure.
Okay, why don't we staple that information to that?
I got a feeling I'm gonna try to pull some money together and get like my own attorney who's actually gonna like be here.
That's up to you. Just
well, you know,
get to
because
them
I was
sooner than
blindsided
later.
by all this, and then based on what he said right now, I mean that's not right. I mean, like you don't even know the situation, but then you got that all like that's fine. That's fine. Because I'm not the one crying. She's the one crying. This is hurting her more than it's gonna hurt me. Seriously.
If you do hire an attorney, get them on sooner than later so they can help you out.
I'm not the one who's
All right, so why don't you come on up here?
I'm not the one who gets swung on.
Well, Mr.
I'm the
Eastwood,
one who,
maybe
like,
you can
says
come on
if he
up
doesn't
here
agree
and
with
pick up the
something, he gets freaking
information
hit.
for Mr. Haston, and then we can allow him to be on his way. Keep your eyes up here, and then you can be on your way. Thanks, Mr. Haston. And so I'd ask Ms. Haston, you just stay here for about 10 minutes, 10:15, let him clear the area. I'm not taking any further discussion on the case. I know you disagree, and you're free to be in touch with defense and the prosecutor's office, and certainly through Ms.
How do I take
Cervantes.
care of our house for 5 acres by myself?
And I can't help you with all of this. I'm sorry, Ms. Haston, but we're going to move on.
Thank you for the
So, Ms.
patience and helping me navigate the Zoom platform.
All right. So, Ms. Capone, any other clients?
The only other thing.
So we know she's going to drop all charges. She's not going to press charges. The wife isn't going to press charges. And, he'll be home soon, probably right after the next hearing. We all know this. We all know it's going to happen. But kudos, Mr. Prosecutor and Judge, because I think, and I don't know, but I feel that she was going to stop the no contact order at the beginning. And even after the prosecutor said, I don't think it's a good idea, I still think she was going to, only because it's Washington. And the defense attorney was right. In Washington, they have to use the least restrictive means to getting what they want. So the least restrictive means here was to get rid of the no contact order. But he's an idiot, and he had to open his mouth and be an idiot, and now he can't go home. So I'm a grown adult, and so are most of the people watching because I see the age groups. We all know better than to yell at a judge, even if we're mad. So, how does something like this happen? How does a grown adult get in front of a judge and act like that? How? They have to know somehow that it's just not going to do anything but make things worse. And the defender, the attorney defending him, she half-hearted tried. Mr. Hastings, I don't think you should. Because I think he chewed her out. I think he chewed her out in that phone call and then hung up on her. So she's like, I have no opinion on his bond right now. I thought that was so funny. Oh my gosh. All right, now we're going to go to the subset. And it's just crazy. I mean, it just really doesn't get much more crazy than this. But, you know, they keep doing it.
53rd Circuit Court for the County of Sheboygan. I'm sorry, we are actually in the 89th District Court. This case is an 89th District Court case. We're conducting a hearing in the Circuit Court room. It's being clerked from the 89th District Courtroom that has participated by video conference technology into the hearing. And I am providing public access both in the courtroom and also online. So for that reason, we request that nobody would try to record or photograph anything during the hearing, as that can be disruptive to the proceeding. So we'll call the matter in the matter of contempt of Beth Michelle Bridgman. It's filed under the case of People State of Michigan versus Flores, filed 23-868SD. So Ms. Bridgman, if you want to come forward to the table.
I'm unable to do that. I don't have a license to practice law in the bar arena and in the water. I am a woman on the land, under the law of the land, and under the one true God. I'm a living soul. And
okay, I mean,
you're offered a contract with Beth Michelle Bridgman in all caps. I'm not that person. Anybody else in this room that person?
Hey, hang on.
Okay.
So Miss Bridgman, you're correct that the bar in the courtroom, people have to be licensed attorneys to cross the bar to represent other people. Of course, people can and do, as you have, represented yourself on this side of the bar. So you're welcome to sit at the table there, which would perhaps be more comfortable for you. If you would prefer to proceed from where you're standing or sitting, that's fine with me as well. Do you have a preference then?
I'd like to stay right here.
Okay, that's
my
great.
honor. I think the first matter I need to address is that I have a copy of your sworn oath here, and
that's not relevant for today. So Ms. Bridgman, you filed a motion for me to recuse myself. I'm going to deny that motion. It didn't present any basis for recusal. So that motion is denied. And we're here for a contempt hearing, which you've been arraigned on for your contempt for interfering in the court process and the unauthorized practice of law, and then failing to attend the hearing.
This is true.
So Ms. Miller, any opening statements?
Yes, Your Honor. I will share with you the evidence that Ms. Bridgman engaged in the unauthorized practice of law that is contrary to MCL 600.916. She further prevented the defendant in the underlying case from meeting with his MIDC attorney prior to his arraignment on November 30th, 2023, and she also failed to appear for her show cause on December 20th, 2023 at 11 a.m. Thank you.
All right, do you wish any witnesses sequestered?
I don't believe so.
Okay, Ms. Bridgman, now's the time you can make your opening statement to me, but first, do you wish to have any witnesses that will be presented sequestered, meaning that they have to leave the courtroom and be instructed to not watch the
I'm not even contracted with this hearing, this administrative hearing cannot be, I cannot be adulterous to my own oath of office.
I'm going to assume that
And
you're
put
rejecting
myself
my
under an
request for
authority.
sequestration orders and no sequestration orders center. So go ahead with your opening statement.
Law is, must be a contract. In the absence of a valid contract, there is no law, period, which might be part of the problem that we have here. Now,
I don't mean to interrupt you, and I'm not going to interrupt you often during your opening statement. I do want you to know that because of the way the video feed works, from where you're standing, it's not picking you up. And I assume that the audio is going to work through for the district courtroom that's clipping it. But
I'm content with all the people
okay.
that are here that
All right,
reside on the land that most of us call Michigan. If that's who is bringing charges against me and there is no person injured, there's no property damage, there should be no case. So my statement is that how can I put myself in your jurisdiction, except that you could do it by force and arrest me with 4 deputies with no due process and violate my unalienable rights to try to force me into your jurisdiction? Because your oath of office is a violation of Section 5, United States Code 3001. You do not have an oath giver. You have yourself that signed it, and you have a notary. I just did an oath with the people here today, and they signed it, I signed it, and we got a couple of them notarized. That's how it should be. This is not a valid oath. I cannot stand in this court and be brought up because, in fact, you are operating or masquerading as a lawful court, but you're in fraud of the very oath that would give your court legitimacy. I have a remedy, Your Honor. I have an oath here, and if you would like to take it in the presence of the people and sign and notarized, we can move forward. Otherwise, I would be violating my very own oath of office and an oath I just took downstairs as well to the United States of America's Constitution.
Real quick, let's just all take a shot every time she says unalienable wrong.
All right, does that conclude your opening remarks?
Well, it concludes the fact that I see that you're not interested or care what the people and the truth of the lawful process of the people. I don't know if anybody else cares to say that. There's no injury and there's no property damage. I do believe I withheld Mr. Gilbert from some money he was probably banking on that day. And I believe the court operates in commerce and is here to make a profit on all of their activities. So that is my violation. The state of Michigan hated that I blocked an attorney before Seth was arraigned. You cannot be bringing me in the hallway downstairs and charging me, and then tell me that you're the true judge of the 53rd Circuit Court when your oath is not properly even administered. I happen to know, I believe, did you take a Bar Association oath?
I'm not answering questions. Are you done with your opening statement?
I guess I don't really need to be here because this is not a legitimate court that I should be standing in. And I will not violate my own oath by submitting myself to an authority that has not done the proper oath himself.
All right, Ms. Miller, your first witness.
Thank you, Your Honor. People would call.
Ms. Bridgman, you may not leave the courtroom.
I know you have people that need to know that they are violating people's unalienable rights by picking them off the street without a single piece of paperwork.
Okay, Ms. Miller, who's your first witness?
People call.
Does anybody else have a problem with this?
Oh. All right, hang on. There's going to be no outbursts in the courtroom or you'll have to be removed. All right, Mr. Bird, please raise your right hand. You may not leave the courtroom. You swear to tell the truth, the whole truth, and nothing but the truth, so bad? Yes. Okay.
I'd be happy to administer a
Ms.
legitimate oath.
Bridgman, hang on. So the court process works. I gave you both a chance for your opening statements.
This is not a
Hold on,
court
hold on.
I can submit to.
Hold on. The process is going to be.
I know you like to look really regal up there and maintain a degree of authority, and you have guys carrying guns.
Ms. Bridgman.
I'm fully aware of that. Where are their body cams and their vehicle
I
cams?
can put you in a jail cell. You can watch it from there.
I know that's what you're hoping to do.
So Ms. Miller is going to be given an opportunity to question the witness, and then you'll be given an opportunity to question the witnesses. That's how court procedure operates. If you interfere with that procedure, you're going to be in direct contempt of court. Ms. Miller, proceed with your question.
I would have to be.
Can you state your name for the record?
David Berg.
And can you spell your last name?
BERG.
And how are you employed?
I'm the IT director for Sheboygan County.
And in that capacity, are you able to see and access the surveillance footage in the building?
Yes, I am.
And are you able to pull portions of that video off the server?
I am.
And were you working that capacity on November 30th, 2023?
Yes.
And are you aware of security footage that was pulled from the system for that date?
Yes, I am.
Do you know what the time frame of that security footage that was pulled was?
8 to 10.
And do you know what part of the building was pulled from the system for that time frame?
I believe there were about 5 camera views, mainly downstairs in front of district court in the entryway.
Okay. And did you review this thumb drive prior to sitting here to testify today?
Yes, I did.
And does everything on this thumb drive, was that pulled from the system from November 30th?
Objection, this is all hearsay. Anything that is on that video is all hearsay.
It hasn't been offered into evidence yet, so hold on a second.
So you were able to view everything on the thumb drive?
Yes.
And was that all footage from those cameras from November 30th?
Hearsay.
Yes, it was.
It hasn't been offered into evidence yet. Hold on a second.
And
no, I know your presumptions are that if it's said in court and it's not objected, it becomes presumptive evidence.
All he said is that he reviewed it. So continue.
And did it appear to be
She is leading the
edited in
witness.
any way?
I'm sorry, what's that?
Did it appear to be edited in any way?
No, software that we have does not allow us to edit.
So it's the full capture of that
Yes.
time frame.
Yes.
Okay, I'd move to admit People's Exhibit 1.
Okay, Exhibit 1 has been offered for admission. Ms. Bridgman, do you have an objection?
I have an objection that anything in the hallway is going to be considered contempt of court.
Okay, it is, I'm going to presume that that's an objection as to relevance. It is relevant. Objection overruled. Exhibit 1 is admitted.
Thank you.
So, my honor, can we move to settle this? Because I know your main objective is to get me into jail unconstitutionally again.
Ms. Bridgman, I assure you that is not my objective today. If it is your objective, there's easy ways that you can make that happen by continuing to behave the way that you are. But I assure you that is not my intention today. All right, so 1 is admitted.
Thank you, Your Honor. The time frame on the video is 2 hours. I don't think the court wants to, I don't want to show the full 2-hour video. If I would be allowed to present various snippets of relevant time from the video.
Okay, go ahead. All right, so Ms. Bridgman, Ms. Miller's going to play portions of the security footage for the court. I'm not sure if you're able to see it from where you are standing. Again, I invite you, you're welcome to sit at the table where you can see the footage.
I was there, Your Honor, and before the living God, I know what's on that video, and I have not violated or broken any laws. I have stood in the way of your Commerce Court, so I understand that that's a contempt of court charge because you're a for-profit court.
Go ahead.
And for the record, my office did contact Ms. Bridgman to offer to give her a copy of the flash drive or have put on a flash drive for her, and she indicated that she did not want a copy.
Okay, go ahead and play. And about how long is this footage?
The various clips that I show will be approximately 5 minutes.
I'm not seeing anything.
Yeah, the focus is right here.
I can't see anything.
Okay, well, I can move the TV closer to the
Well,
bench.
I don't know if that'll help. That's way off in the corner.
I can move to the next clip and see if the court can see anything on that. But
I mean, I see there's people down in the hall. I don't see how it would help me render a decision.
well, then I can just reserve to show the clips in case we need to later on. Then I have no further questions for Mr. Burke.
All right, Ms. Bridgman, do you have any questions for the witness, Steve Burke?
When's the last time you were at Salvation Army with your daughter?
Couple weeks probably.
Okay. Sorry, I missed it. That's all I got.
Okay, thank you. Your next witness.
Thank you, Your Honor. Other people would call Seth Flores.
Now, Your Honor, before you call the next witness, I would love to be in honor in your courtroom. And I would ask that we would settle to save this young man.
We're in the middle of it here. Mr. Flores, would you please raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Okay.
Can you state your name for the record?
Seth Flores,
And can you spell your last name?
Flores.
Okay, thank you. And were you present in this building on November 30th, 2023?
Yes, I believe so.
Why did you come to the building on that day?
I had a court date for an arraignment,
Okay, do you remember what time you showed up at the court?
I think around 10, maybe.
And when you came into the building, what happened?
Walked in, Beth approached me. Seemed like she wanted to help me. She told me I didn't need a lawyer. And the judge suggested that I should talk to one.
Okay, can I stop you for a minute? You said Beth approached you. Do you see Beth in the courtroom today?
Yeah.
What's she wearing?
Jacket.
I asked the court to, for the record to reflect that Mr. Flores is identified as Bridgman.
And the district court is clerking it, and they're telling me they're having a hard time hearing the witness. Mr. Flores, can you speak up and maybe use your outside voice?
Yeah.
Should I repeat the question?
No, go ahead.
Okay. And so before you walked into the building on the 30th, did you know Beth?
No.
You just met her on that day?
Yeah.
And when you went into the courtroom, did anyone go with you?
No.
You don't remember anyone being in the courtroom with you?
They didn't walk in with me, or
I guess I can clarify. Once you were in the building and then you went into the room where the judge is, did anyone go
Okay,
with you
leading the
into that
witness,
building?
come on.
But that's just laying overrules. Go ahead.
yes, I walked in the courtroom.
I thought you would have prepped him better than this page.
Ms. Bridgman, that is not a proper objection. That's an interjection. That's disorderly. Don't do that. I know you're an adult human being, so you're capable of controlling yourself. So please do so. This is a format that has to be dignified and follow proper procedures and be orderly.
Okay, you just made my case, Judge, because your oath is not properly in order.
Mr. Flores, so just to repeat, when you went into the room with the judge, did anyone go with you?
Just Beth.
Okay. And at some point when you were in the room, do you remember if Beth said anything to the judge?
That I didn't need a lawyer.
I didn't say that in the court.
Hang on, you
Leading the
can't.
witness. You're
Bridgman,
putting
you
words in
can't-
his mouth.
You'll have an opportunity to ask questions, but you can't interject during.
Well, I have to object.
And then at some point, did the judge tell you to do anything?
Speak to a lawyer.
Okay. Did you ever speak to a lawyer on that day?
What's your objection?
She's just leading. She's taking them through every step, which I can refute. And she's telling them, you should have done this prior, Paige. You should have had them in here earlier and prepped them.
She asked him a question, did this happen? And he said, yes, that's perfectly
That's
proper.
leading.
That is
No,
not
she
leading.
should ask him what
Objection.
happened.
Do you recall what happened when you tried to, or when an attorney approached you in the hallway?
Beth tried speaking to him and wouldn't let him speak to him.
Do you remember who that lawyer was?
Gilbert,
And were you ever able to talk to Gilbert about your arraignment?
only after,
What do you mean by only after?
like, I don't think I did. Maybe like a couple of days or a week after.
Okay, but not on the 30th. Did you ever
No.
talk to Mr. Gilbert?
Not on that day, no.
And did you ever give any paperwork back to the court that morning?
Yes, I did.
Did you write anything on that paper?
Can we ask him what he did? Objection?
She is overruled.
No, she's not.
Not completely sure what I wrote on the ticket. Something about it's my personal vehicle, or it wasn't my personal vehicle, and I wasn't driving.
Why did you write that on your ticket?
That suggested me to.
And does that mean anything to you, what you wrote on the paper?
Not necessarily.
So you said that Beth suggested that you write that on your ticket?
Yes.
And what did you do with the ticket after you wrote on it?
I think I turned it into the civil court desk.
But you don't have a transcriber, you have to keep all the notes yourself, or is that what's going on?
So
Ms.
after,
Bridgman, that's not a proper objection. Stop misbehaving. You know how to behave.
I'm not sure I'm the only one in bad behavior, Your Honor, according to Article 2, or Article 3, Section 2 court,
Go ahead, Ms. Newman.
you might be in bad behavior.
Your Honor, may I approach the witness?
Why don't you hand it to the bailiff? We'll have the bailiff do that.
Is that a copy of your ticket? And is that your handwriting on it?
Yes,
Is that what you turned into the court?
I believe so.
Your Honor, I guess I would ask the court to take judicial notice of the ticket. I believe it's in the court's file already on what Mr. Flores turned into the district window on November 30th.
It is or not, but I'll also take judicial notice of the court's own records. Do you have it marked as an exhibit?
I do.
Is it, what number is it?
It's exhibit 2.
2 will be admitted.
Thank you.
He looks so young and innocent. I just feel so bad for this little boy.
And then after you gave your ticket to the window, what did you do next?
I was advised to leave.
Who advised you to leave?
Beth.
So at that point, did you leave?
Yeah.
At any point in that morning, did you address the court on your ticket?
No, I did not.
And after you initially were told to meet with an attorney, did you ever go back into the courtroom?
I think about a week later.
Okay, but that day, did you ever go back?
No.
And following leaving the courtroom, what did you do after that?
Just went out and got some lunch.
Okay, who did you do that with? You remember where that was?
Not really sure. Libby's maybe.
Okay, and then, did,
Sorry, Mr. Flores, you're really gonna have to use your outside voice.
and while you were at lunch, did, Ms. Bridgman ever give you any money?
No. Oh, for my phone, yes.
So did she give you any money?
Yeah,
How much money did she give you?
$60.
And what, was that $60 in cash?
Yes.
And that occurred after the same day as the court arraignment in the morning?
I believe so.
I don't have any more questions for this witness.
All right, Ms. Bridgman, do you have any questions for Mr. Flores?
Sure.
Go ahead.
Good to see you, sir. I'm sorry it's under these circumstances. The way I recall it, you were talking to some of my friends before we talked, or we were talking and then we went out into the hallway, but.
Your Honor, I guess I'd object, that's not a question.
Sure, you'll have a chance to offer testimony under oath if you want, but you just made a statement about your recollection.
Okay.
You can ask questions of this witness.
Okay, Seth. Let's see, did I injure you in any way that day?
No.
Did I cause you to lose money in any way that day?
No.
Did you tell me about what Deputy Dukowski had been saying to you on your 2 other MIPs?
Yeah. Yes.
Did I suggest or offer some information to you that you had willingly, as a passenger in a vehicle, surrendered all of your God-given rights, and you did not need to do that?
Yeah.
And that you have the right to stand up under common law and not be placed through tyrannical police measures.
Yes.
Did you tell me what Officer Dukowski said when he pulled you over? What was the reason he pulled you over that night?
He did not state a reason.
Was it something about on Butler Road in what I could recall?
I believe he told us, or the driver, my friend, that he crossed the center line.
I believe you had told me the white line.
Yeah.
The white line, which is not the center line. And there are no white lines out there on Butler when you turn off. How far did Deputy Dukowski follow you that night?
Your Honor, I guess I'd object to the relevance of the question.
I'll overrule it. Go ahead and answer the question.
From Subway to Butler Road. They said that we crossed the line by Subway, but I don't recall.
Okay. I recall you, and listen, I know this was a high stress environment for you, okay? And I have many friends in town who have gone through this same thing.
I guess I'd object again
so,
to the question.
Well, I think she's laying the groundwork for a question.
Because
you have to end up at a question.
if you've gone through 3 years of COVID in the schools and complied with everything, you're very compliant. He did comply with me. I offered him liberty. You offered him, maybe Dukowski talked about taking his vehicle. Is that right?
Yes.
Are those the terms you had told me?
Yes.
Yeah. As a passenger, did you really have to surrender to all those things that you cooperated with them on?
No.
No.
Not completely.
No. And so was I offering, I know that this county doesn't like common law, but it's actually still on the books and it's a natural recourse. And there are plenty of laws that say if nobody's hurt and nobody was injured, there is no crime. So I was suggesting that you stand up for your rights for once, because I don't even know where you guys got the alcohol. Can you tell me where you got the alcohol?
There you go. We ask questions.
Can you tell me where you got the alcohol?
Well, hold on. I'm not gonna have you asked Mr. Flores any more about the underlying substance of his case? Because he would have certain privilege rights against self-incrimination.
Okay.
So I'm not gonna do that.
You had just gotten off work, is that right?
No.
How long had you been off work?
Probably a couple hours. I got off around 8.
And it was what time were you picked up?
But again, I guess, I will go back and sustain the earlier objection. What happened during the traffic stop with Mr. Flores is not relevant to the question of whether you unlawfully gave him legal advice at the courthouse or interfered with his arraignments or failed to appear for the show cause.
So stay with me,
that's
Your
relevant.
Honor, because I believe there were some deals cut in order to target me.
Well, ask him that. Ask him if
Okay.
he knows of any deals.
Were
that
there
were cut
any
for
deals
whatever.
made to keep somebody that you love from harm if you testified against me?
No, we had the court date and the charges were dropped to two civil infractions. And then after the court case, I was sent a letter in the mail to be here today to testify.
So were you charged with anything after they sent you the letter? Because I remember you called me that night. Or you messaged me that night and said they sent you a letter in the mail
That was
to pull you back into their jurisdiction like they did me. Only they arrested me, Seth, so yes.
that was previous letters from the court.
That had shown up. But it worried you. It worried you. I know it worried you. What did I suggest that you do? Because I don't know how parents leave kids, and the first thing kids should do is text their mom and dad, get over here, I got the cops pulling me over again in the middle of the night. Now, you had told me that you were pulled over at 3 a.m. Is that right?
I believe so, yes.
Again, I would object about the underlying case.
Right, but again, the facts and circumstances of his, of the stop are not relevant. It's just.
I believe that we're protecting somebody here, Your Honor. I think it is pertinent. And I'm not afraid to go down as the bad person, even though I didn't harm Seth and I didn't cause him any property damage. Is that right, Seth?
Yeah. Well, he did say that. I do want to ask you, Mr. Flores, you said that it was just dropped to 2 civil infractions. Was that conditioned in any way on your offering testimony in this matter?
No.
All right, go ahead and continue.
Well, I know it can be subtle, right, Seth? Would you say that when you're in authority's presence, you are probably going through some form of high anxiety?
Yes, I'm nervous when I get pulled over.
Yes. And do you know that people can completely forget? I've worked with at-risk kids, taking tests and everything else, and they can completely forget what has occurred. And they're open to suggestions. And I know how to calm kids down. And was I not willing to stand with you if you were going to be pulled over? Did I not tell you if Dukowski came at you for the 4th time to get a hold of me?
Yeah, I felt more confident after that, but I'm still nervous when cops pull me over, even when I'm not in the wrong.
Is it possible because of your high anxiety around, and this, you're not alone in this, dude. I can show you a dozen people in this room at least who have high anxiety around this place and anything having to do with it. And these gentlemen, is it possible that some of your memory today is not exactly right?
Maybe not 100%.
Do you think I felt I needed to protect you and Gilbert? Because I knew what Gilbert was trying to do. He was trying to put you back in their jurisdiction. They're trying to make money off of you. And I was preventing that, right?
I felt guided almost.
You felt what?
I felt guided almost because nobody was really telling me what to do.
Yeah. So there were a few details that I would say I recollect differently, but I would no more put any of my friends in the jurisdiction of his authority and this court's authority and subpoenas and bonds and everything else to testify against you.
Okay, that's not the
Because
question.
I don't
Ask your
care, Your
question.
Honor. I'm here to protect Seth
All right.
and anybody else.
Can you redirect?
Yes. Mr. Flores, do you recall when you came back to the court after that arraignment day?
Maybe a week after.
Okay, and at that point, do you recall if you resolved your underlying case with civil infractions?
Yes, we did that day.
Okay.
This wasn't a use of battery, there's use of codes.
Hang on,
and statutes.
Mister, you'll have to leave the court.
I'm out of here, thank you for your time.
All right, thank you, sir.
Thank you, Nick.
Ridiculous.
So you resolved your case of civil infractions, you said a week after?
Yes.
And then at some point, did you come for did the court issue a show cause against you?
I can't recall.
Okay, do you remember if there was another hearing that was held after you?
Are we not just leaving
entered
and
your
then I
show
just
causes?
substantiate that he
Hang on, the
by
question, the
threat
objection
environment,
was,
people forget?
hang on, the objection was leading, that is the leading question sustained.
I think after the.
Hang on, the question, there was an objection to the question, I sustained it, so we have to wait for another question.
So did you provide testimony in your underlying case at some other time, other than today?
During the civil infractions, when I got charged.
Okay, do you remember what the date was?
I do not. I do not know the date. I think it was December, sometime December.
But you don't remember why you were testifying?
I don't recall.
And you said earlier that you felt guided while you were dealing with Miss Bridgman. Who did you feel was guiding you?
Miss Bridgman, because nobody really directed me where to go, and it was one of my first experiences here, so I didn't really know what was going on.
Do you remember if the judge ever told you where to go?
After we entered the courtroom, he advised that I should talk to a lawyer.
But at that point, did you already feel guided?
I kind of felt I didn't know who to trust.
I think this is kind of an asked and answer.
Okay. I don't have any more questions then.
All right, Mr. Flores, thank you for your testimony and acceptance. Any additional witnesses, Ms. Stone?
Yes, Your Honor, the people would call Mr. Gilbert.
Oh, this is part of the bar. Click. Let's do this, Jim.
Gilbert, raise your right hand for me. You solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Can you state your name for the record?
James Gilbert.
And how are you employed?
Primarily, I am a public defender for Sheboygan and Prescott County.
And were you working in that capacity on November 30th, 2023?
I was the MIDC arraignment attorney that day, plus I had my own caseload.
Are you familiar with Seth Flores?
Yes, I've met him.
How are you familiar?
I knew him briefly that day. Because
Isn't this all hearsay?
his case got called.
Your video? Oh, because he's a qualified bar association member?
No, he's testifying from his personal knowledge, so that objection is overruled. Go ahead.
And then I later met him on a one-on-one level after his mother brought him back into the county building a few days or a week later.
Okay, so back on the 30th, did you ever meet with Mr. Flores?
Not one-on-one.
Did you ever attempt to meet with Mr. Flores?
I did.
Can you tell me about that attempt?
Oh, yes. I was in the courtroom, and at some point in time, his case was called. And usually what happens is the people, as they come in, go up to our office on this floor, and we meet with them there before their arraignment to tell them what's going to happen. I had not met with Mr. Florence. He was in the courtroom. Judge Visna called his case and asked if he had met with the arraignment attorney. He said no, and Judge Visna told him that he should meet with me. And then what happened was there was another gentleman in the room that made some comment about I wasn't going to represent him, and just to tell the court that I wasn't going to meet with them. I said I can't do that. I need to finish up with a couple of cases, and I'd be out for Halloween to meet with them. And a little bit later, I attempted to do that.
Wow.
Can you tell me about the attempt in the hallway?
Yes, I walked out into the hallway and Mr. Florence was there with the lady that's here in the courtroom. And
The woman, the living soul.
okay. But on 3 attempts, I tried to talk to Mr. Florence, and each time I was
That shit
interrupted.
crazy.
Wasn't allowed to talk to him.
And who interrupted you?
The woman in the courtroom in the green jacket or coat.
Okay, isn't this some kind of bar association star chamber thing we got going on here? Wow.
Ms. Bridgman's testimony under oath, and you'll have a chance for cross-examination.
Okay, I just
Stop interrupting.
invalidated your oath. What does testimony under oath mean in this county?
Ms. Bridgman, I mean, I've warned you repeatedly. I don't know if you're having some enjoyment out of that, but I really want you to participate in the courtroom fully from this. If you continue to disrupt it, I'll have you watch it from a jail cell over video and I'll mute you and you can just listen. But I don't want to do that. I want you to participate fully. Will you please cooperate with me in that and let the process go forward? I mean, we got to have a hearing. So
I see what I
a
see
star
what you
chamber
did
is something
here.
that determines guilt without a hearing. So
I'd like
we're
to
having a
see
hearing.
Gilbert's
Go ahead
oath
with
of
the next
office.
question.
And I got yours.
So you said you were interrupted 3 times. Is that what you said?
That's correct.
Okay, at some point, or what did you do after that?
After that, I just I went back up to our office, and at that time there was like the person that's in charge was a gentleman, Mr. Keogh. I just reported what had happened, and pretty much that was it. I learned later that Mr. Florence had left the building.
Okay, and then did you so at any point did you assist Mr. Flores with an arraignment on that day?
I did not.
And at any point were you able to go over the facts of his case and advise him of his rights?
I was not. I attempted on 3 times, and I don't remember the exact order. I, at one point, tried to explain in the hallway what my job was. The lady, here, Ms. Bridgman, interrupted me at one point in time and said, no, his job is to scare the hell out of you. That was one time. She interrupted. I tried again. I was told that Mr. Florence was not going to contract with me. And I thought the two of them worked together. And then there was a 3rd time I was interrupted, and I basically said, okay, I'm done.
And then at some point later, you met with Mr. Flores?
That was a couple days later, a couple days or possibly a week.
And
I don't remember exactly.
do you recall if there was any other hearings in his case?
I was subpoenaed, as I was today, for I believe, a show cause hearing for Mr. Florence that I had to testify at, and I believe that was in December.
Do you remember what the underlying show cause was?
For his failure to stay for the arraignment.
And that would have been the arraignment on the 30th?
Correct.
I don't have any more questions, Mr. Gilbert.
Ms. Bridgman, any cross-exam questions for Mr. Gilbert?
Yes. So you take a kid who's anxious, gave away all of his inalienable rights when if he gave his driver's license to Kowski, just violated the law. He was a passenger in the vehicle. And he didn't give accurate testimony, but I'm not going to make him perjure himself. And everything you just said does not line up with people that I have here that were there. Do you want me to call witnesses, Your Honor?
Okay, you haven't asked the witness a question.
Okay.
So I'm going to assume you don't want to ask the witness a question.
Was Seth really in the courtroom and arraigned and approached by you in the courtroom?
He was never arraigned. He was in the courtroom, and the judge advised that he needed to speak with me. And I said I had 2 more matters. I'd be out in the hallway, and that's where you and him were waiting out in the hallway. That's when I tried to approach Mr. Flores.
Did Seth and were we aware that the judge, because was it perhaps that when Seth turned in the paperwork to the clerk of court, that she let the judge know and the judge let you know, go out there and get him, and she's talking to him and you better go get him arraigned? You better go talk to him? Because I already had him out there and done before you were ever on the scene. You took all of his inalienable rights, violated due process for the kid, and then you're trying to make him put him in your jurisdiction, and I was saving him from that because.
Do you have a question for Mr. Gilbert?
Yes.
Ask it.
Are you prepared to perjure yourself? Okay, it's nice that, I'm glad I didn't
That's
take
not
a
a proper
360.
question. I'm going to determine that Ms. Bridgman is elected, that she doesn't want to ask.
Okay,
Mr. Gilbert
let me ask
question.
him.
She just wants to rail against him. Mr. Gilbert, you can step down.
Yeah, how do you ask questions of when you've all cooked this all up between yourselves?
Ms. Miller, your next witness.
Your Honor, I don't have any further witnesses in this matter.
Okay. And the court will take judicial notice of its own files and the transcript of the arraignment on November 30th, the transcript of the order to show cause on December 21st, and on the failure to appear, the court will take judicial notice of Ms. Bridgman's returning the order to show up, the order to appear, cut into strips with the writing your offer to contract is not accepted, as well as the statements that she made at her arraignment on the bench warrant. All right, so Ms. Bridgman, do you have any witnesses that you wish to present?
I have to say that even being here today and putting myself and submitting myself to your authority that has not been substantiated goes against the one and living God that I respond to. You cannot.
Okay, so I've given you an
opportunity. Anybody want to go stand on what happened that day? But I don't want anybody to enter your jurisdiction, Your Honor, because,
so you're not calling
my honor. Let's do it this way.
Hang on. So so I've offered you an opportunity to call witnesses and you've elected not to. Closing arguments, Ms. Miller.
Your Honor, I'd ask that the court find Ms. Bridgman in contempt for the unauthorized, for interfering with Mr. Flores' arraignment from the MIDC and engaging in unauthorized practice of law. There was testimony that Mr. Flores didn't know Ms. Bridgman before he entered the courtroom the courthouse on the 30th, that she approached him, that she was with him when she was with him in the courtroom. She told him that he didn't need a lawyer. She was providing legal advice to him, saying that he didn't need to, he was driving his personal vehicle and he didn't need to engage with the process. He testified that she told him what to write on the ticket to provide to the court. I asked the court to take judicial notice of the ticket with Mr. Flores' writing on it. He testified that once he turned it in, he was advised to leave the building by Ms. Bridgman before he had his arraignment.
Wow.
So I would, and then further the testimony of Mr. Gilbert, that he was the arraignment attorney, that he was in the courtroom when the judge indicated that Mr. Flores should meet with him. He testified that Ms. Bridgman interrupted him 3 times from meeting with Mr. Flores, that he tried to but wasn't able to. He wasn't able to advise him of his rights or to go over the ticket with him, and further that Mr. Flores left without being arraigned on the matter.
Is it still possible to object to all these presumptive evidences? You brought your own people in who are on the county payroll.
It's closing argument. Go ahead. You
And I would
have your
ask-
chance.
Then I would ask the court, I think it's clear that Ms. Bridgman was interfering with Mr. Flores's meeting with the arraignment attorney by physically preventing Mr. Gilbert from meeting with him, further telling him what to put on a piece of a document to submit to the court on his behalf. That would also be engaging in giving him legal advice. So I find I'd ask the court to find her contempt on that. And I'd also ask the court to find her contempt for failing to appear on the show cause that was issued to her on the 20th of December. Thank you.
All right, thank you. Ms. Bridgman, now's your opportunity to make any closing argument that you wish. Go ahead.
I am not in this hearing situation. This has been conducted as what is called a star chamber. As all of our founding fathers left because the Bar Association members are arraigned against a witness and they have no due process. Has anybody here not witnessed a breach of public trust and due process?
Yes.
Well, people could judge for themselves. We've conducted a hearing. People can testify.
It's not a hearing, it's a witch hunt.
Hang on. No.
There was no.
Conclude your closing argument. All right. Any further outbursts, you'll have to leave or you'll be taken into custody.
So practicing law, none of you have an actual license to practice law. Did you know that, right? A bar association membership is not a license. You're not registered on LARA, the state's licensing administration. You're not registered. Your primary oath is to the bar association. We know about your secret commitments to one another and not to follow the unalienable rights of the people and due process.
It's the people's court.
This is not, you have just set up a star chamber and you've got guys with guns ready to carry out whatever you want, and you have not even taken enough care about the people and your situation in the court to execute a proper oath. You should have had somebody swear that oath to you. You can't sign your own oath and have it notarized. You did that with the prosecutor. You have to have somebody who swore you in, signing it, and then a notary. It takes 3 people. I should not be submitted. If somebody is practicing law without a license, it's all of you bar association members.
Yep.
No, there is no license. It's a private membership. And I cannot subject myself as a living soul to an authority that violates my God-given unalienable rights. And if you gentlemen carry that out, have you any idea what you're doing, what you're being asked to do? You need to think about it, because I can tell you right now, our military is watching every move you make right now. This is your opportunity to stand for the people and not for the people that are trying to steal every one of our rights as they did with Seth Flores. You should be ashamed of yourself, Deputy Dukowski. You told him on his second MIP you were going to take his vehicle and he was going to have to pay $12,000 to get it out of the impound. Do you know how many friends I have that can't drive a freaking car in this county up until the age of 35? I don't practice law. I practice rights. I practice people living free and supporting one another. So if your court finds me guilty, your court is finding every God-given right the universe has ever known to be a fraud. We would be happy to administer the real oath for you today, Judge Gaffia. We have a body of people. We would be happy to do that. We need a district court judge for the people to reinstate common law. The Bar Association has bought out the entire state of Michigan for the CCP. I know what that means. I know what your role in that means. And I believe redemption is for everyone. And I could be your best friend to make, I believe you know God's truth. I believe you want to do God's truth. And I believe you could be the man that we need. But we have to leave this process of the Bar Association, and you have to take an accurate oath.
I'll witness it.
I'll witness it too, out there.
All right, thank you, Ms. Bridgman. And now I'll make the ruling. Article 6 of Michigan's Constitution of 1963 vests the judicial power of the state of Michigan in the Supreme Court and courts of record as established by law. It also gives the Supreme Court superintending control over all the lower courts. Michigan's Constitution also provides for the passage of public acts passed by the legislature and approved by the governor. These statutes, despite bad information that people get online, have the force of law. Michigan has a statutory system regulating the practice of law. Michigan compiled law 600.901 through 949. Section 904 vests the Supreme Court with the power over the state. Ms. Bridgman, you may not leave the courtroom.
I'm going to talk to somebody. I'm not trying to get away, Dukowski. You won't see me at 3 a.m. on Butler Road.
I'm giving my ruling here.
Okay.
Section 904 vests the Supreme Court with power over the State Bar of Michigan, which under Section 901 is a public body corporate consisting of all persons licensed to practice law in Michigan. Section 916 makes it illegal for anyone to practice law unless they're licensed to do so.
You're not
The
licensed.
Michigan Supreme Court in State Bar v. Kramer, 399 Mich 116 in 1976, noted that this statutory scheme merely recognizes the inherent authority of the courts at common law to control the practice of law, dating back to the common law of England. When so-called sovereign citizens complain about the common law, they neglect to notice that the common law was what courts said.
Codes and
This
statutes
regulation is
are
rooted
not
in the
law.
importance of protecting the public from the danger of unskilled persons practicing law.
Oh my goodness.
What constitutes the practice of law? In Dressel v. Ameribank, the Michigan Supreme Court in 2003 held that a person engages in the practice of law when he counsels or assists another in matters that require the use of legal discretion and profound legal knowledge.
So, Your Honor, where
Now,
was
basic
that
free
in my
speech
latest
protection
charges?
Protect the right of people to espouse beliefs and to tell other people about those beliefs.
Ryan,
So Ms. Bridgman has the free speech right to believe what she wants to about courts and government and to tell other people about that. This includes, of course, criticism of government and of the courts, but to give advice, guidance, and assistance to another person in their own legal matter at the courthouse to be applied to their particular case at that time crosses the line into the practice of law. At its heart, the practice of law is applying legal knowledge to a particular issue or problem. This unauthorized practice of law is a contempt of court.
you had that written up earlier, didn't you?
Additionally, interfering with someone meeting with their attorney is a disruption of the court process and is therefore also a contempt of court.
He was not there to
The
meet
primary
his
purpose of
attorney
the
yet.
contempt power is to preserve the effectiveness and sustain the power of the court. The power to hold a party in contempt is inherent in the judiciary, yet still the legislature has recognized this and codified it. This is merely a recognition of the common law contempt power of courts. Among these statutes, Section 600, Section 1701H provides that any court of record may hold in contempt all persons for assuming to be and acting as officers, attorneys, or counselors of any court without authority,
Good word.
or for other unlawful interference with or resistance to the process or proceedings in any action. So interfering with a person's consultation with an appointed attorney is directed by a judge, interferes with that process in that court case, and is a contempt of court.
But I tell you,
Let's just pretend.
There are
Doesn't even
two forms of contempt, civil and criminal. Civil contempt applies when someone refuses to obey a court order and the court coerces their compliance. So in civil contempt, the person can contempt by obeying the order. Criminal contempt
you
applies
guys
to
put
past
hands on
actions.
me today.
For failure to appear as a criminal contempt.
Be careful.
The court, Ms. Bridgman. You've had your, I've given you
Aaron,
every
you are
opportunity.
misbehaving. You had this prepared. You
I
hooked it
am.
up with your witnesses. Come on
The Court
now.
of Appeals has specifically.
I was not
held
practicing
criminal
law.
contempt
I was practicing rights. Common law and the Constitution is about rights, not law,
So the court
not your
finds,
legal
finds
stuff.
Ms. Bridgman in contempt of court
Oh, yes.
for the unauthorized practice of law in giving Mr. Flores advice particular to his situation on what to write on his ticket as a lawful defense, to disobey the court's direction to consult with the MIDC attorney, which is required by law, and to leave the
By codes and
courthouse as he
statutes.
was not authorized to do so. And that resulted in harm to Mr. Flores. There was he was in jeopardy of contempt of court by leaving without finishing the arraignment process by
My
following
honor.
the bad advice of Ms. Bridgman.
I am
That
not
was a
wanting to be in
of court
contempt
by
of court.
practicing law. It's a contempt of court for interfering with the court process. Ms. Bridgman is also in contempt of court for failing to appear for the show cause hearing when she didn't show up for it, but she instead beforehand turned in the order, cut up into little pieces with the statement, your offer to contract is not accepted.
You trespassed on my yard with
Courts
no,
have the inherent authority to
right.
compel attendance, and she is in contempt of court for doing that. So Ms. Bridgman is in contempt of court for unauthorized practice of law and for the interfering with the court process on November 30th, 2023. She's also in contempt of court for failing to appear
oh, this
for
house,
her
I
show
know,
cause
that's right on
hearing.
me. Better be careful. I know some jujitsu.
What day was that scheduled for?
Oh, I remember.
On December 20, I'm sorry.
I'm gonna pull you behind.
Oops.
So, my honor.
So she's in contempt of court for failing to appear on December 20th. All right, Ms. Miller, any allocution as to sentence?
Your Honor, it's concerning whenever a person is not able to participate in the judicial process in accordance with their rights. So I think that's the biggest issue. Is that Mr. Flores wasn't able to meet with MIDC, left without being arraigned. So I just asked the court to keep that.
That's right.
In its consideration when issuing a sentence.
All right, Ms. Bridgman, do you have anything you wish to say before the court pronounces sentence for the contempt?
Under common law, which is the only true law because it comes from God's natural law, and the Constitution is based on that. The Constitution is not about law, it's about rights. I was not talking to Mr. Flores about any legal thing because I'm not a bar association lawyer. I don't know about all your laws. I do know that the need to have a attorney at arraignment, from what State Trooper Brenda Casperson told me, only started a year ago. That is codes and statutes. We are not bound by that. We are living beings. We are not the corporate dead entity of the court system. I did not practice law. I practiced his rights. Do you know there are plenty of other counties in this state that accept that same documentation that I filed and had Seth file? I was hoping to make him unafraid of all of these. He has good things to say about a couple of your deputies. They're not all like that. This court is for profit. So standing in the way of that attorney, but that testimony, Mr. Gilbert, you should be ashamed of yourself, was not truthful. You had never approached.
All right, Ms. Bridgman, this is your opportunity to tell me what penalty I should give you, if any.
Was anybody harmed? Was there any other financial damage to Seth Flores? I know there was to Mr. Gilbert because he lost a client that day, but then he recovered that. Good. Okay. Are we not allowed to talk to people in the courthouse, not in the courtroom? Is that not a public space? Are we not allowed to help a fellow citizen understand that he doesn't have to lose everything in his life as he's just getting started? That he can have people stand with him and encourage him and coach him through, maybe handle his drinking. I suggested that he stop drinking and he start to, pay attention, and we'll be there if he gets pulled over because he's afraid. I don't see where there has been any harm. And if you can rule that as contempt, I have no longer I see no ability to redeem anything in this courtroom. You refuse to address your oath. And if you hold me in contempt of court, I think that's quite unbelievable.
Absolutely.
All right, well, I've already
Yeah,
I
I do have somebody who would like to make a statement on my behalf.
No, that's not allowed. All right, so I have filed
you're
a
judge, jury.
Yeah, you've made all your statements. I have filed an oath proper under the laws. I filed the constitutional oath required by Article 1, Section 11 of the state constitution. All these sovereign citizen folks who get these crazy arguments online that are frankly just wrong. I encourage you, read the state constitution. You'll find that all this stuff you're getting from seminars or whatever online is just false. And Mr. Flores, to his harm, listened to it and almost got held in contempt. Ms. Bridgman has total disregard for the court's authority. Courts are the way that citizens have recourse to the law. In societies that don't have a court system, they don't have the rule of law. You end up with the rule of the bully. And the court protects citizens from the government several times. There's important business to be had. There was important business to be had for Mr. Flores that day.
I don't think
and Ms. Bridgman interfered. And she totally refused to appear for court willfully. Her conduct today has been directly contumacious. And she has exhibited repeated disregard, and frankly, utter contempt for not only this court, but for really any court. And so.
Under the
any
Bar
process of law-
Association, I believe so. You're not
So-
upholding anything to the Constitution, and
You know,
the state Constitution
I do
can't.
need to give a sentence that is proportionate, but also is enough to discourage Ms. Bridgman from this type of interference, and also to discourage other people from following down a similar path. So Ms. Bridgman, you're ordered a 30 days jail served forthwith.
Nothing can come with me, okay?
You know, guys, you need to arrest the judge for impersonating a public official. You need to arrest the judge for impersonating a public official. Okay, are you concerned at all about what you're being asked to do?
Judge, when does it have to be started? She can serve her 30 days anytime.
Mr. Flores said no harm was done to him.
You didn't say a date on when it should start. Can we talk about that?
Put me in cuffs like
Does that start right at this moment? Just let me go home and come back. Work with it.
What is your first name? Darren. Okay. I need you to listen to the citizens of this community and understand, no, how are we ever going to give back a constitutional sheriff? You're not following anything about our inalienable rights. No, the military has a way to deal with it. I know. Oh, thanks for coming in, Lieutenant Tebow, because I mean, I only go into jail with 4 deputies. I mean, anything less would be an insult.
Do you want somebody to take this up or bring it back with you?
No, this is corruption. My daughter. She follows the law, the rights.
Let's go, let's go. Ma'am, come on. Let's go.
Kowalski?
Kowalski. Let's go.
Kowalski. All right, guys. We're just gonna let this stand. A man with a fraudulent oath of office. I can't wait to look into yours, Paige.
Keep going, come on, please, thank
Yeah, I
you.
know.
Thank you.
Keep going.
You guys need to pick the right side.
Let's go.
Yes,
Yeah,
you need
come on,
to
come on,
sign,
come
sign.
on.
No,
Let's
you
go.
are the people. We are. Stop it, Zatelsky. I know what I'm.
Let's go.
Stop it.
Let's go.
You got time.
No, it could be. It could be you next time. Someday the right person will get.
Your
it wrong.
deputies have no right
Corruption.
to ask
You
a
guys don't have any
passenger
rights.
for their driver's license.
Okay.
That is illegal.
We need a clear the
Someday somebody will take your rights away. He's here. He's just lining up his people. Are you going to tell your deputies that?
Man, we need to clear the courtroom.
Are you going to answer this?
I will tell them whatever you want me to tell them.
They have no right to ask for a passenger's driver's license.
Okay, I'll tell her that.
It should be enforced.
Yes, sir.
Wonder if everybody's gone.
Yes.
I want you to know I'm Joe Klein. Okay. And I'm the lead man for the Sanctuary Counties. In this county. I made several speeches on behalf of you guys. Not only here in this county, but Pressfield and down in, Otsego. And my focus, yes, Sacramento. And my focus was to protect you guys from these red flag laws. I didn't want you guys going into the house at 3:00. You know the drill. You've been there, okay? And this is, I'm just saying, this was this woman and other people like that. I've done a lot of research.
Okay, we need to clear the courtroom. Can you get the hall clear? I'll take it back.
Yeah, I'll be ready.
Sorry, we just got.
Wow. Yeah, that was crazy. I mean, I really don't have many words because that was just crazy. 30 days. I hope that kid isn't going to get in trouble. I hope he doesn't listen to them. I just feel so bad for him. But maybe, I don't know. It sounded in his testimony that he sort of believed them, but he sort of doesn't because he got in trouble. I don't know. He's just a little kid. But man, that was exhausting. I feel like I worked a shift going through that. And I don't know how the people, I don't know how the prosecutor didn't like laugh half the time at how crazy it was. Or the judge. And the judge did us dirty today because we've seen this judge. We love this judge. We've seen this judge send someone to jail for 30 days for way, way less. Way less. And he just allowed this to happen. And I didn't think he would. But I think I know why. Because it's highly publicized, this sick, crazy woman. So for appeals and everything else, he just was just, this is what's going to happen. I know she's going to go crazy. I'm just going to get through this case. But man, we've seen him. And I know she was sent to jail for 30 days, but she should have been sent to jail for contempt today. Because that's the way he does it. He doesn't deal with stuff like this. And today he did. Probably because there were so many people watching. I guess he just thought he'd be good. We didn't want that, though. We don't want people disrespecting our courts like that. At all. Ever. I'm trying to think. I mean, I'm glad she was in front of him, but I'm trying to think who we would have rather her been in front of. Which judges would have been the best. But no, he's a good judge. I love him. So we're going to let him slide on this one. I'm going to let him slide on not contempting her. Guys, thanks for coming out today. I really, really appreciate it. I'm going to go grab a couple hours of sleep before work, and I will see you next time.